Proposition 8. In California, Proposition 8 holds that no relevant evidence in a criminal case will be inadmissible unless a Proposition 8 exception applies. The court still has power to exclude evidence using legal relevance balancing. Logical relevance. 401. Evidence is relevant if 1. It's probative, and 2. Material. Probative. Evidence has a tendency to make a fact more or less probable than it would be without the evidence, and material. The fact is of consequence in determining the action. Under California, the fact must also be disputed. Legal relevance. 403. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following. Wu Cummin. Wasting time, undue prejudice, confusing the issues, undue delay, misleading the jury, or needlessly presenting cumulative evidence. Limited admissibility. The court may admit relevant evidence for a specific purpose and nothing else that would be inadmissible under FRE 403. Preliminary facts and laying foundation. Court preliminary questions. The court must decide any preliminary question about whether a witness is qualified, a privilege exists, or if evidence is admissible. In so deciding, the court is not bound by evidence rules except on privilege. In California, a California judge who applies the CEC rules is also bound by the rules of evidence. Jury preliminary facts. When the relevance of evidence depends on whether a fact exists, sufficient proof must be introduced to the jury to support a finding that the fact does exist. The court may admit the proposed evidence on the condition that the proof be introduced later. Conducting a hearing outside jury presence. The court must conduct any hearing on a preliminary question so that the jury cannot hear it if the hearing involves confessions, a defendant in a criminal case is a witness and requests, or if justice requires. Authentication 901. All evidence other than testimony must be authenticated as genuine in order to be admitted. Authentication is proof that the item is what the proponent claims it is. There are different methods of authentication: real evidence, demonstrative evidence, writings and recordings, ancient documents, self-authenticating documents. Real evidence. Physical evidence that can be authenticated, testimony by someone with personal knowledge of distinctive characteristics or chains of custody. Demonstrative evidence. Evidence demonstrating something must be a fair representation. Writings or recordings. Writings and recordings may be authenticated by admissions, eyewitness testimony, voice identification, handwriting verifications, which are expert or non-expert with personal knowledge, or a trier of fact with comparisons, circumstantial evidence, which could be postmark address, etc. Ancient documents. Ancient documents may be authenticated by evidence that the document is in condition to be free from suspicion of inauthenticity, was found in a place such a writing would be kept, and it is at least 30 years old under the FRE or 20 years old under the CEC. Self-authenticating documents. Certain documents are self-authenticating, such as certified copies of public records or deeds, official publications, newspapers, and periodicals. Under the FRE, business records and trade inscriptions apply. Under the CEC, signature of notary or domestic public employee is sufficient. Best and secondary evidence rules. The best evidence rule and secondary evidence rule apply when a party seeks to prove the contents of a writing. Under the best evidence rule, the federal rule requires an original document to be produced to prove a writing, recording, or photograph, including electronic and videos, unless statute provides otherwise. Exception. An original is not required when the original was lost or destroyed, and not by the proponent acting in bad faith. The original cannot be obtained by judicial process. The opponent was in control of the original, noticed the proponent's intent to use it, but failed to produce it, or 4. The original is not closely related to a controlling issue. Under California's secondary evidence rule, secondary evidence is evidence that is reproduced from an original document. The content of a writing may be admissible by secondary evidence. The court shall exclude secondary evidence and require the original if 1. There is a dispute about important terms of a writing, or 2. If it would be unfair to admit secondary evidence. Exclusion for secondary evidence. In criminal cases, secondary evidence is inadmissible if 1. The original is in the proponent's possession or control, and 2. The proponent has not made the original available for inspection. Summary of voluminous writing. If original documents are so voluminous that they can't be conveniently introduced into evidence, a summary may be introduced through a sponsoring witness. Judicial notice. When a court takes judicial notice of a fact, there is no need for evidence of that fact. Simply put, judicial notice is a substitute for evidence. Judicial notice. The court's acceptance of a fact as true without formal proof must not be subject to reasonable dispute, and 1. Must be generally known in the trial court's jurisdiction, or 2. Accurately and readily determined from sources whose accuracy cannot be questioned. Under timing, the court may take judicial notice at any time during the proceeding, including appeal, a party request, or sua sponte. Sua sponte means the judge acts on his own initiative. Request to be heard. A judge may give an adverse party an opportunity to be heard when requested. Instructing the jury. A civil jury must be instructed to accept a noticed fact as conclusive. However, the court must inform a criminal jury that it may not accept it. The court will not take judicial notice of facts that are subject to dispute. Under California, in criminal or civil proceedings, judges are required to take judicial notice of constitutional, statutory, and case law from California and the federal government. Judicial notice is also required of facts and propositions of generalized knowledge that are so universally known that they cannot reasonably be the subject of dispute. Character evidence. There are three types of character evidence. 1, reputation. 2, opinion. And 3, specific acts. The purpose of character evidence and whether it is criminal or civil determines which type of character evidence can be admitted. Character evidence is admissible when the character is an essential element of a claim or defense rather than a means of proving a person's conduct. Character evidence 404. In a civil or criminal case, evidence of a person's character or trait is inadmissible to prove they have a propensity for that trait. Exceptions in civil cases. In a civil case, character evidence is inadmissible for propensity purposes unless the character is an essential element of the claim or defense, or the case involves a claim for relief based on sexual assault or child molestation. In California, character evidence is not admissible in a civil case based on sexual assault, child molestation, domestic violence, or elder abuse. Exceptions in criminal cases. The defendant's good character, or they open the door. A defendant may offer evidence of his pertinent trait to prove his conforming conduct. However, if admitted, the prosecution may offer evidence to rebut it. In California, in a child molestation case, the defendant may offer expert testimony that the defendant is not psychologically disposed to commit the charged sex offenses. Under victim's bad character, a defendant may offer evidence of an alleged victim's bad character to prove the victim's conforming conduct. However, if admitted, the prosecution may offer evidence to rebut it or offer evidence of the defendant's same trait. And this is subject to limitations in Rule 412, which are sexual offense cases. In California, the FRE allows character testimony. However, the CEC allows both character testimony and defendant to offer evidence of specific acts of the victim's conduct to prove the victim's character for violence. Homicide cases. Prosecution may offer evidence of the alleged victim's trait of peacefulness to rebut the defendant's evidence that the victim was the first aggressor. Exceptions for a witness. Character evidence is admissible for impeachment or rehabilitation purposes, so see 607, 608, and 609. Crimes, wrongs, or other acts. Prohibited acts. It uses specific acts of a crime, wrong, or other act is inadmissible for propensity purposes. Permitted uses. Evidence of specific acts in a civil or criminal case may be admissible for non-propensity purposes, including mimic, motive or opportunity, intent, absent of mistake, identity, or common plan or scheme. Notice requirement. Notice in a criminal case, the prosecutor must provide reasonable notice of any such evidence that the prosecutor intends to introduce. Reasonable notice before trial and allow the defendant a fair opportunity to meet the evidence. Habit and routine distinguished. Evidence of a person's habit or an organization's routine practice may be admitted to prove that on a particular occasion, the person or organized action acted in accordance with the habit or routine practice. Public policy exclusions despite relevance. There's subsequent remedial measures, or SRM, when measures are taken that would have made an earlier injury or harm less likely to occur. Evidence of the subsequent measures is inadmissible to prove NCDW, negligence, culpable conduct, defect in product or design, or warning or instruction needed. Exceptions. The court may admit SRM to prove impeachment or, when disputed, proving ownership, control, or feasibility of precautionary measures. You could remember this by IFOC, impeachment, or if disputed, feasibility, or ownership or control. Under California, evidence of SRM can be admissible in strict liability cases. Thus, evidence to prove the following are admissible: a defect in product or design, or warning or instruction is needed. Compromise offers and negotiations. Compromise offers or statements made during settlement negotiations are inadmissible by either party to 1. Prove or disprove the validity or amount of a disputed claim, or impeach by a prior inconsistent statement or contradiction. Exceptions. The court may admit this evidence for other purposes, like proving witness bias or prejudice, disproving undue delay, proving an effort to obstruct a criminal investigation or prosecution, In a criminal case, statements and negotiations related to a claim by a public office in the exercise of his authority. In California, compromise offers and negotiations does not apply to criminal cases. Negotiations and mediation proceedings are not admissible. Offers to pay medical and similar expenses. Evidence of furnishing, promising, or offering to pay medical or similar expenses resulting from an injury is inadmissible to prove liability for that injury. Exceptions. The court may admit this evidence for other purposes, such as conduct or statements that accompany the offer to or promise to pay. Under California benevolent gestures, statements and writings relating to pain, suffering, or death after an accident made to a person or his family are inadmissible in civil cases. Pleas, discussions, and related statements. In a civil or criminal case, evidence of the following are inadmissible against the defendant who made a plea or participated in plea discussions: withdrawn guilty pleas, nolo contendere pleas, statements made while negotiating a plea with prosecution, or statements made during a plea proceeding with a prosecuting attorney if the discussion did not result in a guilty plea or resulted in a later withdrawn guilty plea. Exceptions. The defendant may waive his protections if the waiver is made knowingly and voluntarily. The court may admit statements in 3 or 4 if 1. The statement was introduced for context or completeness purposes, or 2. In a perjury or false statement case, the defendant made the statement under oath, on the record, and with counsel present. In California, the CEC protects all statements made as part of a bona fide plea negotiations. The CEC permits the use of statements made during plea negotiations to impeach a defendant's trial testimony. Liability insurance. Evidence that a person was or was not insured against liability is inadmissible to prove a person's CAN, culpable conduct, ability to pay, or negligence. Exceptions. The court may admit this evidence to prove WACO, witness bias for prejudice, agency, control, or ownership. Sexual assault cases regarding character evidence. Sex offense cases 412. In civil or criminal cases involving sexual misconduct, evidence is inadmissible to prove the victim 1. Engaged in other sexual behavior, or 2. Had a sexual predisposition. Exceptions. In criminal cases, the court may admit evidence if specific acts of victim's sexual behavior is offered to prove 1. Someone other than the defendant was the source of semen, injury, or other physical violence. 2. The victim consented. Or 3. Excluded evidence would violate the defendant's constitutional rights. In civil cases, the court may admit evidence if the victim's sexual behavior or sexual predisposition, if its probative value substantially outweighs the danger of harm to any victim and of unfair prejudice to any party. Sexual assault or child molestation in a criminal case. In a criminal case where the defendant is accused of sexual assault or child molestation, the court may admit evidence that the defendant committed any other sexual assault or child molestation when relevant. If the prosecution intends to offer this evidence, they must disclose it to the defendant at least 15 days before trial. Sexual assault or child molestation in civil cases. In a civil case where a claim for relief is based on a party's alleged sexual assault or child molestation, the court may admit evidence that the party committed any sexual assault or child molestation. Witness competency. Competency to testify. Every person is presumed competent to be a witness unless the FRE provides otherwise. The following raises issues of admissibility. MAC-D. Mental or moral competency, ability to communicate, child competency, dead man statute, which is the surviving party to a contract is prohibited from testifying about dealings with their deceased opponents. In California, the dead man statute does not apply. Need for personal knowledge. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. This rule does not apply to expert witnesses' testimony. A judge as a witness. A presiding judge may not testify as a witness at a trial. A party need not object to preserve the issue. In California, however, a presiding judge may testify if no party objects. A juror as a witness. At trial, a juror may not testify as a witness before other jurors at trial. A party may object outside the jury's presence if a juror is called to testify. After trial, a juror may not testify if 1. About any statements or incidents during deliberations during an inquiry into the validity of a verdict indictment, 2. On the effect on a juror's vote, or 3. On any juror's mental processes concerning the verdict or indictment. The court may not receive the juror's affidavit or evidence of a juror's statement on these matters. However, a juror may testify about whether a mistake was made entering the verdict on the verdict form, an outside influence was improperly brought to bear on any juror, or extraneous prejudicial information was improperly brought to the jury's attention. Excluding witnesses. The court must order witnesses excluded at a party's request so they cannot hear other witnesses' testimony. The court cannot exclude the following: 1. Natural persons. 2. Officer or employee after being designated as the party's representative by its attorney. 3. Essential person to present the party's claim or defense. Or 4. Person authorized by statute to be present. Lay witness opinion testimony. A lay witness may testify in the form of an opinion if the opinion is 1. Based on the witness's perception, meaning personal knowledge, 2. Helpful to determine the fact and issue, and 3. Not based on scientific, technical, or specialized knowledge, STS. Expert witness opinion testimony, FRE 702. An expert witness may testify in the form of an opinion or otherwise if 1. They have specialized knowledge that will assist the trier of fact. 2. The witness has qualified STS knowledge, that is scientific, technical, or specialized knowledge. 3. The testimony is based on sufficient facts. Under the FRE, there's the Daubert and Kumbo test. The expert's testimony must meet the following standards of reliability. That 1, it's peer-reviewed and published in scientific journals. 2, it's tested and subject to retesting. 3, it's known for low error rate. And 4, subject to a reasonable level of acceptance. Under California, the Kelly-Frye test applies. The expert's testimony must meet the following standard of reliability. The proponent must prove that the underlying scientific theory and instrument it uses, and 2, it has been generally accepted as valid and reliable in the relevant scientific community. Ultimate issue. An expert opinion may be admissible even though the opinion embraces the ultimate issue in the case. However, in a criminal case, an expert witness must not give an opinion whether the defendant had the mental state that constitutes an element of the crime charged or of a defense. Impeachment. A witness's credibility may be impeached by cross-examination or with proper foundation by extrinsic evidence. Either party may impeach a witness. There are 5 ways to impeach a witness: prior inconsistent statements, or PIS. A party may impeach a witness by presenting evidence that the witness made prior statements that were inconsistent with his current testimony. Extrinsic evidence of a witness's PIS is admissible only if 1. The witness is given an opportunity to explain or deny the statement, and 2. The adverse party is given an opportunity to examine the witness about it. Exception. No foundation is required when PIS impeaches the hearsay declarant or is not admitted for its truth, meaning hearsay. In California, the CEC provides a hearsay exception for all PIS. Thus, in California, PIS are admissible to impeach and for the truth of the matter asserted. Bias. A party may impeach a witness by presenting extrinsic evidence that the witness is biased. There are 2 main categories of bias. 1. A witness has favorable or hostile relationship with a party to the action, and or the witness has a stake in the outcome of the action. Sensory defects, no FRE. A party may impeach a witness by presenting extrinsic evidence that the witness is unable to perceive information effectively. Extrinsic evidence of sensory defects are generally admissible even without laying foundation. Impeachment by contradiction. This is California only. A witness may be impeached when their testimony deviates substantially from what accurately happened. Character for truthfulness. A witness's character for truthfulness can be attacked or supported by testimony shown by reputation or opinion, past crimes, and or specific acts. Repetition or opinion evidence. Repetition or opinion evidence of truthful character is allowed after the witness's truthful character is attacked. Evidence used to rehab an impeached witness must directly relate to the impeachment evidence. Specific acts. Extrinsic evidence of specific acts is inadmissible to support or attack the witness's character for truthfulness or untruthfulness, meaning the questioner must accept the answer and the witness gives. However, specific instances of conduct may be admissible if 1. The evidence is introduced on cross-examination, 2. The conduct is probative to the character for truthfulness or untruthfulness, and 3. A good faith basis for the inquiry exists. In California, in civil court, extrinsic evidence is prohibited and initial cross-examination. In criminal court, Proposition 8 permits both the initial cross-examination and the extrinsic evidence subject to relevance legal balancing test. Impeaching with criminal conviction. 609. The following rules apply to attacking a witness's character for truthfulness by evidence of a criminal conviction regarding dishonest acts, false statements, such as forgery, perjury, or embezzlement. Crimes punishable by death or imprisonment for a year or more. The evidence here must be admitted if 1. Subject to FRE 403 in a criminal case or civil case where the witness is not a defendant, and 2. In a criminal case where the witness is a defendant if the probative value of the evidence just outweighs its prejudicial effect to that defendant. In California, misdemeanors cannot be used to impeach a witness. In criminal, misdemeanors can only be used if the crime involved moral turpitude. Any crime regardless of punishment. The evidence must be admitted if the court can readily determine that establishing the elements of the crime required proving, or the witness is admitting a dishonest act or false statement. Using evidence after 10 years. If more than 10 years passed since the witness's conviction or release from confinement, evidence is admissible only if 1. Probative value substantially outweighs its prejudicial effect and is supported by specific facts and circumstances, and the proponent is an adverse party, gives an adverse party reasonable notice of intent to use it, so the adverse party has a fair opportunity to contest its use. Pardons, annulments, or certificates or rehabilitation. Evidence of a criminal conviction is inadmissible if the conviction has been subject to a pardon, annulment, or certificate of rehabilitation, and the person has not been convicted of a later crime punishable by death or imprisonment for a year or more, or the conviction is subject to a pardon, annulment, or an equivalent if the person is found innocent. Juvenile adjudications. Evidence of a juvenile adjudication is admissible only if it is offered in a criminal case. 2. The adjudication was of a witness other than defendant. 3. The adult's conviction for that offense would be admissible to attack the adult's credibility. And 4. Admitting the evidence is necessary to fairly determine guilt or innocence. Pending appeal. A conviction that satisfies any of this rule is admissible, even if an appeal is pending. Evidence of a pendency of an appeal is also admissible. Religious belief or opinion. A witness's credibility cannot be attacked or supported based on the witness's religious belief or opinion. However, it is okay to introduce their religious beliefs for bias. Privilege. Privileges provide testimony protection for a certain relationship, allowing one claiming the privilege to refuse to disclose or prohibit others from disclosing specified confidential information. Spousal immunity. A witness in a valid marriage may refuse to testify against their spouse in a criminal proceeding on information learned before or during the marriage. A witness spouse holds privilege and chooses whether or not to testify. Immunity expires when the marriage ends. In California, spousal immunity may be asserted in any proceeding. Confidential marital communications. Communication between spouses are privileged against any compelled disclosure in any proceeding if the communication is intended to be confidential and made during a valid marriage. Both spouses hold the privilege, and privilege extends beyond the marriage. Exception. Marital communication exception applies when 1. Spouses sue each other, or 2. A spouse is charged with a crime against the other spouse. In California, charged crimes of bigamy and fraud also apply here. Physician-patient privilege. Communication between physicians and their patients are privileged if the communications were 1. Intended to be confidential, and 2. Made to facilitate medical diagnosis or treatment. This privilege does not apply when the patient puts his physical condition at issue in a lawsuit. 2. Medical services are sought to further crime or fraud. 3. There is litigation involving medical malpractice. Or 4. Patient contractually agreed to waive privilege. Psychotherapist-patient privilege. Psychotherapist-client privilege covers confidential communications between patients and psychotherapists. Federal and all states permit psychotherapist-patient privilege. Under the scope, the patient is the holder of privilege, and the psychotherapist is required to assert it on the patient's behalf. The privilege can apply to individual or group therapy. Exceptions. Psychotherapist patient privilege communication does not apply to 1. Patient's mental condition at issue. 2. Communication was a result of the court-ordered exam of the patient. 3. The proceeding involves whether to commit the patient. 4. Patient is a danger to himself or others. Or 5. Psychotherapist is required to report the patient is younger than 16 and a psychotherapist believes that he is a victim of abuse. Attorney-client privilege. Communication between attorneys and their clients or people seeking to become a client are privileged communication if they were 1. Intended to be confidential. 2. Made between attorney and client or prospective client. And 3. Made to facilitate legal services. The clients hold privilege until he waives it and extends even after death. In California, the privilege ends when the client dies, his estate is fully distributed, and personal representative waives that privilege. If the client is a corporation, some states, the attorney-client privilege is limited to control group members, which are directors and officers. Under federal law, an attorney-client privilege extends to non-control group members if they are communicating to seek legal advice for the corporation. Under exceptions, the attorney-client privilege does not apply when legal services are sought to further a crime or fraud, there is litigation involving a malpractice, or the co-clients are later adverse parties involved in civil litigation against each other. In California, in crimes or fraud, attorneys can break privilege to prevent future commission of what the client should have known was crime or fraud. Attorney-client privilege waiver. Intentional disclosure of confidential communications to a third party constitutes a waiver to attorney-client privilege. Inadvertent disclosure does not waive privilege if the client took reasonable steps to prevent and rectify the disclosure. Under work product doctrine protects confidential information related to an attorney's representation of a client and provides that any material prepared by the attorney in anticipation of litigation are protected against disclosure unless one party demonstrates a substantial need for the evidence. Self-incrimination privilege. Under the Fifth Amendment, witnesses may refuse to testify if the testimony may incriminate themselves. Under scope, self-incrimination privileges do not apply to corporations, prior statements, foreign prosecution, acquitted or convicted charges unless it can lead to further charges. Prosecution comments. Prosecution cannot comment in a civil case that the defendant failed to take the stand, but plaintiff can argue this in a civil case. Clergy or penitent privilege. So this is the California only. Under the clergy penitent privilege, clergymen must receive communication, and both he and the penitent may assert privilege. Accountant privilege. The accountant privilege does not exist in federal or California courts. Journalist privilege. California only. Publishers, editors, or reporters cannot be held in contempt for refusing to disclose unpublished information unless the defendant shows that the journalist's source may assist in defense. The court must balance the interests. Government privilege. The government is privileged against disclosing the identity of an informant in a criminal case or non-public information by public officials. In California, a public entity has the privilege to refuse to disclose non-public information acquired in confidence by a public employee in the course of their duty. Counselor case worker privilege. California only. Confidential communication made by a victim to an unauthorized counselor or caseworker for securing advice or assistance is privileged. Under the scope, the victim holds the privilege, but the court can compel disclosure in a child abuse case if the communication's probative value outweighs substantial prejudice against the defendant. Third-party presence. Third-party presence alone during a confidential conversation would destroy privilege. In California, however, California and other states reject the eavesdropper rule as long as the parties take reasonable precautions to communicate in private. Privilege waiver. Privilege may be waived if the privilege holder, 1, untimely asserts privilege, 2, voluntarily discloses the communication, or 3, voluntarily discloses the communication to a third party. In California, one holder of privilege does not waive for the other, and confidential disclosures and furtherance of relationship does not waive it. Hearsay. Hearsay is not admissible unless it falls under a valid exception. Hearsay, FRE 801. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Out of court, it means a statement is out of court when the statement is made outside the proceedings of the current case. Statement. A statement is an assertion made by a human being. It can be a writing or oral or conduct offered to prove the truth of the matter asserted. An out-of-court statement that is not offered to prove the truth of the matter asserted is not hearsay. Other statements that are not hearsay: admissions, out-of-court statements made by a party in a trial that are offered in evidence by an opposing party may be admitted even if it was not based on personal knowledge or expresses an otherwise inadmissible opinion. Judicial admissions. Judicial admissions are made in pleadings or in response to a request for admission under rules of civil procedure and binds a party unless they amend it or withdraw it pending court approval. Machine or animal statements. Noises by animals or machines are not hearsay. Effect on listener. Statements offered to show that the speaker or listener was or should have been alerted to certain facts is not hearsay. Declarant state of mind. A declarant's state of mind may be proven circumstantially from their statements if their mental comprehension is an issue. Impeachment purposes. Prior and consistent statements of the witness are used to impeach them. Verbal acts of independent legal significance. Out-of-court statements that have legal significance and in and of itself are not hearsay. Permissible and non-permissible statements. Statements that are both permissible and prohibited but may be admissible subject to FRE 403 balance. Opinion surveys. Opinion surveys are used to show a belief or state of mind that the declarants are not hearsay. Non-assertive conduct. Nonverbal behavior that is not intended to be a statement is not hearsay. Statements that are not hearsay. An out-of-court statement that is offered to prove the truth of the matter asserted is hearsay unless the statement satisfies the condition enumerated under 801D. Declarant witnesses prior statements, FRE 801D. Out-of-court statements made by the available declarant witness who testifies and is subject to cross-examination are not hearsay if they meet the following: prior and consistent statement. Declarant witness's out-of-court statement is inconsistent with his testimony. In California, all PIS are admissible for the truth of the matter asserted and for impeachment, regardless of whether the statement are subject to penalty of perjury. Prior consistent statement. A declarant's witness's out-of-court statement is consistent with his testimony and is offered to rebut opposing party's charge that the declarant witness's statement is inconsistent with his testimony, or to rehabilitate the declarant witness's credibility as a witness when attacked on another ground. Prior identification statement. A declarant witness who identifies a person as someone he perceived earlier. Opposing parties' statements. Out-of-court statements offered against the opposing party are not hearsay if the statements, 1, were made by opposing party, an individual or representative capacity. 2, were adopted or believed to be true by opposing party. Were made by a person who opposing party authorized to make a statement on the subject. 4, were made by opposing party's agent or employee on a matter within the scope of that relationship and while it existed. Or 5, were made by opposing party's co-conspirator during and in furtherance of the conspiracy. Hearsay exceptions. Unavailability is okay. The following are not excluded by the rule of against hearsay 801, regardless of whether the declarant is available as a witness. So remember this mnemonic: pet Mr. Bap. 1, present sense impression, an out-of-court statement describing an event or condition. 1, of the declarant's conduct or conduct of others. 2, made while or immediately after the declarant perceived it. In California, statements only apply to declarant's conduct and only during the time the declarant perceived it. 2, excited utterance. An out-of-court statement made related to a startling event while the declarant was still under the stress or excitement. 3, the then existing state of mind. An out-of-court statement of the then existing state of mind. Or 2, emotional, sensory, or physical condition, but not including a statement of memory or belief to prove the fact remembered or believed unless it relates to a validity or terms of declarant's will. In California, a declarant's statement about their state of mind at an earlier time is admissible if 1, the declarant is unavailable, and 2, their earlier state of mind is an issue. 4, medical diagnosis or treatment statements. An out-of-court statement that 1, is made for and is reasonably pertinent to the medical diagnosis or treatment, and 2, describes medical history, past or present symptoms or sensations, their inception or their general cause. In California, the exception only applies to children's statements in child abuse cases, so the child must be under 12 and still a minor at the time of the proceeding. Recorded recollection. A record that is on a matter the witness once knew about, but cannot now recall well enough to testify fully and accurately. 2, was made or adopted by the witness when the matter was fresh in their memory. And 3, accurately reflects the witness's knowledge. In California, a forgetful witness must testify that the written statement was accurate. Business records. A record of an act, event, condition, opinion, or diagnosis. If the record was made at or near the time of the subject matter's occurrence by someone with knowledge. 2, was kept in the course of regularly conducted activity of a business or organization. And 3, was a regular practice of that activity. Under the FRE, police records cannot be used against criminal defendants, but witness statements are okay. In California, police records are not business records, but can be public records. Absence of business records. Evidence that is admitted to prove that the matter is not included in a record because it did not occur. Public records. A record statement of a public office is admissible if it sets out 1, the office activities, 2, a matter observed while under a legal duty to report a matter observed by law enforcement, but not a matter observed by law enforcement in a criminal case, or 3, in a civil case or against the government in a criminal case, factual findings from a legally authorized investigation, and 4, the opponent does not show that the source of information or other circumstances indicated a lack of trustworthiness. In California, it requires the record to have been made near or near the time the event was recorded. Unavailable declarants. FRE 804. Certain kinds of hearsay evidence are not excluded from the rule against hearsay when the declarant is unavailable. The criteria for being unavailable. A declarant is considered unavailable as a witness if the declarant is April, absent from the proceeding and the statement's proponent is unable to procure the defendant's attendance or testimony. 2, claims privilege. 3, refuses to testify on the subject matter. 4, is ill or dead. Or 5, lacks memory. In California, lack of memory is not an exception unless it is due to trauma from the alleged crime. Also, refusal is only okay if the declarant is in fear. Hearsay exceptions requiring unavailability. So remember this mnemonic, STDs forever. 1, statements against interest. A statement by an unavailable witness is admissible if the statement is 1, made when a reasonable person believed it to be true when it was made. 2, was so contrary to the declarant's property or financial interest or had a great tendency to invalidate the declarant's claim against someone else or expose the declarant to civilly or criminal liability. Or 3, is supported by corroborating circumstances that indicate the statement is trustworthy. In California, statements against the declarant's social interests are admissible as well, which could be causes hatred, ridicule, or disgrace. 2, former testimony. Former testimony of an unavailable witness is admissible if the testimony was 1, given as a witness at a current trial or a different one, and 2, is now offered against a party who had or in a civil case whose predecessor in interest had an opportunity and similar motive to develop it by direct, cross, or redirect examination. Dying declarations. In a homicide or civil cases, the unavailable witness's dying statement is admissible when the declarant, 1, believes their death to be imminent, and 2, the statement relates to the circumstances of their death. In California, the declarant has to be dead. Also, the CEC allows all admissibility in all civil or criminal proceedings. Statements of personal history. A statement about a declarant's own birth, adoption, legitimacy, etc., even though the declarant had no way of acquiring personal knowledge of the fact. 5, forfeiture of wrongdoing. A statement offered against a party that wrongfully caused the declarant's unavailability as a witness and did so intending that result. In California, a party that is seeking to admit this evidence must establish the requirements by a preponderance of the evidence at a hearing outside the presence of a jury. Hearsay within hearsay. Hearsay within hearsay is not excluded by the rule against hearsay if each part of the combined statements conforms with an exception to the rule. It usually involves business records and public records. The first level, you have to analyze the record. Second level, analyze the information entered in the record by another person. Impeaching a hearsay speaker. When a hearsay statement or statement under an opposing party's statement has been admitted to evidence, the declarant's credibility may be attacked and then supported by evidence admissible. The court may admit evidence of the declarant's inconsistent statement or conduct regardless of when it occurred or whether they had opportunity to explain or deny it. Residual exception. A hearsay statement is not excluded by the rule against hearsay if the statement is not admissible under 803 or 804 if 1, the statement is supported by sufficient guarantees of trustworthiness, and 2, it is more probative on the point than any other evidence. In California, the residual exception is only applicable for reliable statements made by children in child sexual abuse cases. Constitutional limitations or the Confrontation Clause. The Confrontation Clause guarantees a person accused of a crime the right to confront witnesses against them in a criminal action. The use of an out-of-court statement violates the defendant's constitutional rights under the Sixth Amendment. Confrontation Clause if 1, the proceeding is a criminal action. 2, the declarant is unavailable to be cross-examined in trial. 3, the defendant did not have an opportunity to cross-examine the witness at a proceeding or trial. And 4, the statement is testimonial. A statement is testimonial if the declarant would reasonably expect that the statement would be used for prosecution purposes. Statements made by police whose primary purpose is to collect evidence for a future criminal prosecution is testimonial. Statements made to police whose primary purpose is to provide assistance in an ongoing emergency is not testimonial.